Well, if you're confused about the rules on B2C email marketing under the UK's e-privacy rules, in the time it takes to have a cup of tea, we're going to set them out really clearly. And stick with us because at the end, we're going to put up a fantastic summary table straight from the UK ICO. Hi, I'm Robert Bohr, the founder and CEO of Keepable, the award-winning solution saving you time, money and stress on GDPR and all things privacy, giving you a great answer for the board and customers. This video is part of Privacy Kitchen, free video help on everything about privacy, so please do subscribe to see our latest awesome videos, and links are in the notes below as always. Right, B2C email marketing in the UK. Now, we saw in another video that the rules on email marketing are in PECR, the UK's Privacy and Electronic Communications Regulations, which is why everyone calls it PECR, not GDPR. And PECR is a UK law, so it will be with us post-Brexit. So yes, GDPR always applies when you process personal data. It defines consent and it sets out the legitimate interest test, for example. But the rules are in PECR, which takes precedence. Now, in summary, you cannot send B2C marketing emails, namely to consumers, sole practitioners, and unincorporated partnerships, without consent, subject to the soft opt-in exception. The detailed rule is in PECR's Regulation 22, which says you cannot send unsolicited emails for the purpose of direct marketing to an individual subscriber without their prior consent, unless the soft opt-in exemption applies. So unsolicited emails is easy, it's emails they didn't ask for. And an example from the UK ICO, we love examples, a customer submits an online form requesting a double glazing quote. Sending the quote to them is solicited marketing, but any further contact would be unsolicited. For the purpose of direct marketing is pretty clear too. Helpfully, it means the rules don't apply to other purposes. So for example, contacting a customer solely to remind them how to contact you in case of a problem, solely to check that their details are correct, or to update them on your terms and conditions. These are all examples from different regulators. Also, the UK ICO's draft guidance calls these service messages and gives two further examples. A bank calls a customer about the administration of their bank account. The purpose of the call is simply to advise the customer that there's a problem with one of their standing orders. This isn't direct marketing. Secondly, an individual's credit card has variable balance transfer rates. Their card provider emails them to tell them the rate's changing for a limited period. It's a service message. But if you add any marketing aspects to those emails, even tacking on a single sentence, you've transformed that service or other message into a marketing email, and you need to check if PECR's rule applies. So for example, that credit card provider we just mentioned, if they actively encourage the individuals to make use of that rate change offer, then this would fall within the definition of direct marketing, as they're promoting that rate in order to gain further business from the individual. And another one, so a mobile provider sends a text message to a customer that they're reaching their monthly data limit and advises what the data charges are under its contract if they exceed that limit. Because that message is purely informational about the account, it's likely to be viewed as a service message. But if that mobile provider also uses the message to encourage the customer to take up a special offer to buy more data, then that constitutes direct marketing. You've got to apply it to the whole email. Now, bear in mind that for direct marketing purposes is almost anything promoting your aims or ideals, so it's pretty broad. Okay, individual subscriber, this is the part that we think causes the most issues. Individuals, an immediately clear meaning. We're not talking about legal entities like a limited company, a PLC, LLP. Here also, though, for these laws include sole traders and unincorporated partnerships. Think of it that there's no legal entity in the way when you're doing the marketing, so the marketing is basically directed at one of those individuals. Now, subscribers, trickier because it's not a subscriber to your services. It's the person party to a contract for public electronic communication services for the supply of those services. Basically the person who's the customer of the comms service over which they're getting the email. So let's look at two examples here. Take the email firstname.surname@companyaa.com. That person works at company A, and limited company A will be the subscriber for the comm services, not the individual person. Yes, that email is personal data because it identifies a living person and GDPR will apply to how you handle it. But it's not the email of an individual subscriber. The subscriber is the legal entity. Now, I agree, not all business.com emails are definitely of legal entities, but it's a strong indication. Maybe you've got a policy of only selling or marketing to legal entities, so you don't add them to your database if you're not sure. And just to note, emails such as info@keepable.com are not personal data because there's no personal data there, so PECR and GDPR do not apply. On the other hand, with the email firstname.lastname@hotmail.com, it's most likely that it's an individual who's a subscriber and PECR's rules will apply. Again, yes, businesses may well use Hotmail and Gmail, so in practice it's safer to just assume that everyone with a Hotmail or Gmail is an individual subscriber until you find out otherwise. Okay, prior consent. So this is where GDPR comes in, as PECR expressly states that consent is as defined in GDPR. And GDPR defines that as a freely given, specific, informed, unambiguous indication of the data subject's wishes, by which he or she, with a statement or a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. In other words, no pre-tick boxes, inaction or silence is not consent. Say who you are and that you're going to use the email to send marketing to them and that they can withdraw consent at any time. Give a link to your privacy policy for more details, the standard sort of data collection notice. Right, the last part of the rule is the soft opt-in exception, and this is pretty well known. It means you don't need consent to send B2C marketing emails if you satisfy a 5-part test. Number 1, you obtain the email. Number 2, in the course of the sale or negotiations for the sale of a product or service to that person. Number 3, you're marketing your own similar products and services only. And number 4, number 5, the person had a simple free way to refuse or opt out of the use of their email for direct marketing when you collected it and in each such email. So first, you can't get the email from anyone else. You have to have collected it yourself. Secondly, you need to have done so in the course of the sale or negotiations for the sale of a product or service. Now, sale is clear, the person's a customer. But what about negotiations for sale, as that can mean leads too? The UK ICO notes it's not enough simply to send any query. The individual should have actively expressed an interest in buying your products or services by some form of express communication. Helpfully, the UK gives 3 examples, we all have examples, of what might qualify. Requesting a quote, asking for more details of what you offer, and sending an online inquiry to ask if you can order a particular product. And the UK ICO gives 2 that probably don't. Asking if you're going to open more branches in a particular location, and just going to your website and browsing through the site looking at products. Right, third, you can only use that email to market your own similar goods or services, not someone else's. And the you part is interpreted strictly by legal entity, so other group companies, for example, can't rely on your soft opt-in. As to a similar good or service, the UK ICO has given some great examples again and suggests this depends on the reasonable expectations of the data subject, which in turn depends on the context, including the type of business and category of product. And they give 2 examples. A customer buys groceries online from a large supermarket chain. Although for some reason they only bought bread and bananas on that occasion, they might reasonably expect emails about a wide range of products, including bread and fruit, other groceries, and also books, DVDs, kitchen equipment, and other everyday goods commonly sold in supermarkets. However, they're unlikely to expect emails about banking or insurance products sold under the supermarket brand. These products are not bought or sold in a similar context. And lastly, you need to have given the recipient an easy, free way to refuse, both at the time you collected the email and in each marketing email you send. The last bit's easy, you can allow for unsubscribe, but it's the first part that needs careful drafting when you collect that email. So you can see that under UK's PECR, you only need consent for B2C marketing emails. You do not need consent for B2B marketing emails. That's the legal entities and the people who work there. Now, this is an explosive topic, and Europe's basically split on this point, and we'll deal with B2B marketing email in a separate video. Now, we're still waiting on this European e-privacy regulation to give greater consistency across Europe, and we really need it. We'd welcome the full clarity here. The rules are quite different across Europe. But at least for now, the situation in the UK and the UK ICO is very clear. And here's that guide from the UK ICO. It's their at-a-glance guide from 2019 with all the rules on there. Again, the link is in the notes below. So there you go, the UK's B2C email marketing rules. Very straightforward. And please do visit us at keepable.com. Please like if you enjoyed the video. Look at our other videos, including on B2B email marketing and why the rules are in PECR in the first place. Do get involved. Please use #PrivacyKitchen to tell us the questions and topics you want covered. And so stay well in the meantime, and I look forward to seeing you in the Privacy Kitchen soon.